Hello, everybody. Sharon Adams here to talk about trademarks. And today we're going to be talking about having a trademark declared incontestable. That can happen once a trademark is registered, if the trademark has been used continuously for 5 years, and if the trademark was registered on the principal register originally and not on the supplemental register. So I'm going to go through all of that and talk about that. But briefly, that's what this is about. So, yes, having a trademark declared uncontestable through the USPTO. First, I just wanted to mention that after 5 years, a trademark, once it's registered, the trademark must be renewed after 5 years. And the timing for that is between the fifth and the sixth year after registration. The USPTO allows a declaration of use or excusable non-use under Section 18, under Section 8. Section 8 declaration, it's a signed statement that the trademark is in use in commerce with the goods or services listed in the registration, or the trademark is not in use in commerce due to special circumstances that excuse non-use. So mainly, pretty much in all cases, you're going to have used the trademark for the last 5 years continuously to have it renewed. One example of an excuse for non-use, for example, might be during lockdown, if your business was shut down by the government. Let's say you are a restaurant and you couldn't actually serve people during that time because the government locked down your business. That might be considered excusable non-use. I don't know. I haven't actually encountered that situation, but that would be an area where I think that might happen. Generally, most people, they've been using their trademarks for 5 years. After 5 years, they want to have it, they have to renew it after 5 years, or the USPTO will cancel the trademark. So you must renew. And what you have an option to do at that same time, after 5 years, is to have the trademark declared incontestable. So I just gave the USPTO website information here. You can see it at the top. And if you scroll down on this page, you get to what they say about declaration of incontestability under Section 15. And while you can see a Section 15 declaration of incontestability is a signed statement that the owner claims incontestable rights in a trademark registration and continuous use of the trademark for 5 years. Following the filing of a Section 15 declaration, the trademark becomes incontestable. What does that mean? Well, the USPTO says once a trademark is incontestable, various aspects of the registration cannot be challenged by third parties, such as the trademark's validity. And this declaration can only be filed for trademarks that are registered on the principal register. I just want to point out that it's vague, and people are a little unclear about what this declaration of incontestability means. And this is the USPTO information, so I'm going to attempt to explain what it means here. First, I want to just say it only applies to trademarks that are on the principal register. And I'm going to go over the difference between the principal register and the supplemental register, but I'm providing some legal citations here. So 15 USC Code 1065. This is a lot of words that says here, you have a registered mark and the rights of the owner to use such registered mark. Whoops, whoa. Okay. See, it's just like so many words. I know it's in here though. Okay. Here it says incontestable. And yeah, here it is up here at the top, principal register. So a lot of reading of words, but here it says principal register. If I click on it, it'll go to the next slide. So I'm just going to use my cursor here saying, here it says it must be on the principal register. Okay. And then it can be incontestable provided at, and then there's a bunch of other law, which I'm going to try to summarize. But first I want to explain the difference between the principal register and the supplemental register. So I want to talk about this registration, which I just searched and found one that was registered on the supplemental register. There's no particular reason why I chose this one, except, Chat GPT is big right now. And I thought, well, Change GPT is sort of interesting. Well, this is a registration that is registered on the supplemental register. You can see it right here. Register, supplemental. If it says principal, you can have it declared incontestable. But this mark is a supplemental register, and therefore it can never be declared incontestable, even after 5 years of use. So just to maybe talk about why a trademark might be declared uh, to be registered on the supplemental register, why that happens. I'm looking at their trademark application. I looked at the office action, and this is exactly what it said. Registration is refused. Mark is merely descriptive. Descriptive marks are not allowed to register on the principal register. Only a trademark that is non-descriptive or has acquired distinctiveness may be registered on the principal register. And that's what it says here. Registration is refused because the applied for mark, which was changed, GPT, merely describes a feature, ingredient, characteristic, purpose, function, or intended audience of applicant services, and that's where the citation is. A mark is merely descriptive if it immediately conveys information concerning a feature, quality, or characteristic of an applicant's good or services. That's just what it means to be a descriptive mark. And if you ever get an office action like this is how they do it. They go, oh, here's the mark, change GPT. They talk about what it's for because it has to describe the services. And here they go, well, change. They look it up. They always attach to dictionary definitions. Here, change, the act of making something different. GPT, generative pre-trained transformer. Okay, machine learning algorithm. So change GPT is merely descriptive. Can't be registered on the principal register. However, they always give you this advisory, not always, but if in certain situations when it's appropriate, if it's appropriate, the USPTO examining attorney will give an advisory regarding the supplemental register, which says it's been refused registration on the principal register. However, you may respond. You can argue, hey, it's not, it should be on the principal, or you can seek registration on the supplemental register. So that's just a very easy thing to do. Something that, typically you do. If you're going to get refused on the principal register, okay, you can submit your arguments, but hey, maybe just get it registered on the supplemental register. Just knowing that after 5 years of continuous use, you will not be able to get that declared incontestable. Well, what does it mean to get it declared incontestable? Let's see. I already went over this, that it's a signed statement, that it claims it's incontestable. Okay, so here we're going to go into a little more detail. This is the law again. This is just a section of it. 15 USC 115, section B. Okay, to the extent that the rights to use a registered mark has become incontestable, so after you file the section 15 declaration, and it's approved, which generally they are, the registration shall be conclusive evidence of the validity of the registered mark, of the registrant's ownership of the mark, and of the registrant's exclusive right to use the registered trademark in commerce. Well, what does that mean exactly? I mean, these are just the validity. I thought it was valid. You had a registered trademark. Well, one of the things it means is that I already explained that a descriptive trademark cannot be registered on the principal register, but there are actually situations where maybe a mark that potentially could be considered descriptive is registered on the principal register. And after 5 years, if that mark is declared incontestable, that's it. You can't contest that. Whereas before the 5 year period, if a third party wanted to come in and challenge that and say, hey, that mark is merely descriptive, they could do it before the 5 year period. But after that 5 year period, if it's been declared incontestable under section 15, that challenge to a trademark is eliminated. And I'm going to go over a case that goes into that. But just to briefly touch on the other things, registrant's exclusive ownership of the mark. Well, you can't challenge that, and exclusive right to use the mark. We'll go into that in a little bit more detail here too. The case, this. Yes, went up to the Supreme Court. And this is the case. Park and Fly Inc. versus dollar park and fly. So park and fly was the trademark. And I'm going to show, here it is, for those of you in the Bay Area and actually elsewhere, because it was pretty widespread, park and fly. There it is with the registered trademark, okay? So let's take a guess of what this trademark is for. Could be that you park and then you fly. That might be considered descriptive because, I mean, you park your car and then you fly. Yeah, I think that's at least as descriptive as change GPT was descriptive. So, yes. But what happened in this case is that they got the registered trademark, and after 5 years, they did have it declared incontestable. So that's what I mean. Sometimes, hey, every examining attorney is different, and sometimes they let things go through that, in my opinion, are descriptive. Okay. And they go through and they get registered on the principal register. Well, after 5 years, if you file that section 15 and have it declared incontestable, it's incontestable. You can't challenge that. And this was the case. This is where this case was this was where this was figured. This was where this case law was set down in 1985 in Park and Fly Inc. versus Dollar Park and Fly. So the trademark was for Park and Fly, and this other one, they filed an infringement action against Park and Dollar Park and Fly, okay? And Dollar Park and Fly said, hey, we're not infringing, and by the way, your trademark is invalid because it's descriptive. And this is the case where the Supreme Court said no. Once 5 years have gone by and once the trademark is declared incontestable, then that's it. So here's where they say it. The language of the Lanham Act, that's the Trademark Act, also refutes any conclusion that an incontestable mark may be challenged as merely descriptive. Period. End of sentence. Okay, they go on, and there's a lot of more words, but that's basically what it's saying. Hey, you had up until 5 years to bring that challenge. If you didn't bring it before the 5-year period, that's it. The mark is incontestable. You can't challenge it for being merely descriptive. And this is where it says, pursuant to Section 14, a mark may be canceled on the grounds that it is merely descriptive only if the petition to cancel is filed within, as in prior to, 5 years of the date of registration. So that's where the Supreme Court held that. And also in this case, they did also discuss the registrant's exclusive right to use the mark. That was up there in one of the three things listed. And was held in this case also. They were saying, oh, you can't file a lawsuit against us. But the Supreme Court said, no, you have the exclusive right to use the mark. That means you can file an infringement lawsuit. It seems sort of obvious, but hey, things go all the way up to the Supreme Court on stuff like this. All the way to the Supreme Court, 1985, that's a lot of money on that trademark. Like I said, it was very widespread. Like I say, in the Bay Area, we had Park and Fly, and I know they were pretty much nationwide. What happened? Just recently. Park and Fly. Park and Fly. Here it is with the registered trademark. New look, same feel. In other words, it is now the parking spot. So after they went all the way up to the Supreme Court on this trademark, they changed their name. I mean, granted, 40 years later, things change. I mean, maybe less than 40 years later, 35 years later or whatever. But honestly, this is just a side note, but sometimes when people are really heavily involved in trademark disputes, this is the kind of thing that comes to mind. People have spent thousands, and I mean 100,000 or more, I don't know what this costs, dollars, probably more, on a defending and fighting for a trademark, and then they change it. Or they give up on it. You read these cases where there's people fighting over trademarks that you've never heard of. Okay, so here's my message to that. Sometimes maybe I know people get very attached to their names, but sometimes the thing to do is to just be like, I'm going to take all that money and put it into rebranding and marketing myself. So anyway, speaking of rebranding and marketing myself, I'm Sharon Adams. I am a trademark attorney. That's all I do. My contact information is here. I'm in Berkeley. This is my phone number. This is my email address. So just to say again, there's a lot of different facets of trademarks, but it is I think if you have a trademark that is registered on the principal register, it does make sense after 5 years to have it declared incontestable because you have the right, you have a strong defense, as you saw, it can't be declared as descriptive. You have a very strong presumption that your mark is valid. Okay, you just have much more strength in your mark. Of course, a trademark registration is presumed valid, but now it's presumed incontestable and valid. And you have the exclusive right to use that trademark, so you can bring infringement lawsuits. And of course, as it said, that you are the true and legitimate owner of that trademark. That somebody else is not, it does not have the rights to that trademark. So I do a lot of trademarks. Recently, I've been getting people asking me questions about renewing and what it means to have a declaration of incontestability. As you can see, the law is vague. That's, I guess, a feature, not a bug. But anyway, that's how it works. I'm happy to do any kind of a filing for declaration of incontestability or to renew trademarks for people. Sharon Adams from Adams Law Office.